we can read the opinion so that there's zero deference, that there's kind of some deference, we'll call it Skidmore, or that there's more deference, that the court actually didn't change Chevron at all despite all this lofty rhetoric.
It's the Lawfare podcast. I'm Alan Rosenstein, Associate Professor of Law at the University of Minnesota and Senior Editor at Lawfare, co-hosting today with Molly Reynolds, Senior Editor at Lawfare and Senior Fellow at the Brookings Institution. And we're talking with Bridget Dooling, Assistant Professor of Law at The Ohio State University, and Nick Bednar, Associate Professor of Law at the University of Minnesota.
So we'll have to see. I mean, when I talk about kind of waiting for the chips to fall, what I mean is both, what are the lower courts going to be up to? And also, what kind of incentives does or doesn't this shift, for Congress?
Today, we're discussing one of the highest profile cases from this Supreme Court term, Loper Bright Enterprises versus Raimondo, which overturned the decades-long Chevron doctrine about judicial deference to agency interpretations of their own statutes. All right, Bridget, let me start with you. So I think it'd be helpful as background for our listeners, especially those listeners who don't have the luxury of thinking of ad law all day, every day. What was the state of the law until the end of this Supreme Court term when it came to judicial review of agency interpretations of their statutes? So specifically, before Loper Bright, how much did courts actually defer when agencies interpreted ambiguous provisions in their implementing and organic statutes?
Yeah, great question. And just first, thanks so much for having me on. It's a real pleasure to be with y'all today. It really bums me out to think that there are people out there that don't think about administrative law all day. What a loss for them. It is my whole world. Yes. Okay. So let me give you an overview of, what was going on, as you say, before we got Loper Bright. So agencies, big picture, right? Agencies get their power from statutes. They don't have anything that Congress doesn't give them. So understanding what Congress told them to do is hugely important in this space. Because if Congress didn't actually tell an agency to do something, then they do it anyway, right? That means the agency's operating outside the boundaries of the law. So the stakes are pretty high. And that's why this issue ends up being, such a blockbuster, is that this is really about, that whole relationship, that whole ecosystem. So the problem, of course, is that statutes are not always super clear. I hope you're not scandalized by that idea, but it's just a reality of the legislative drafting process that we end up with language sometimes that does not answer all the questions that an agency might need an answer to in order to implement a particular program or write a rule or issue a grant, for example. Now, that lack of clarity might be an accident, or it might be intentional. It might be part of the compromising process that is part of legislative drafting. So down the road, when someone challenges a rule based on the legal interpretation that an agency made of a statute, they do that in court. So courts are asked to resolve the matter. And it's at this moment where deference doctrines either go to work or not. Judges end up having to decide how to approach their job of interpretation, especially when the language is simply unclear. And in this scenario, a judge has a very sophisticated party in front of them with important information about the statute and the program and the stakes and the interconnections between this and other statutes, et cetera. And that's the agency, right? There might be hundreds of people in an agency working on a program that a judge is maybe only just hearing about in this case that's before them. So the question is, should the judge pay special heed to an agency's views on what the law means or not? Or how exactly are they supposed to navigate that? And on a scale of 0 to absolute deference, here's some options, right? So one option might be to treat the agency like a regular party. No special consideration or deference at all. This option really isn't on the table, even under, the case Loper Bright. Another option is to take very seriously the agency's views and give them weight, but not the kind of weight that's always going to settle the issue. Let's call that Skidmore deference.
And so just to be clear, when you say Skidmore, you're referring to this sort of older case that comes before Chevron, which provides for some low but non-zero level of deference.
You got it. That's right. Thanks for that. Another, again, moving along the line from 0 to absolute deference, another option would be, and these are all options for the judge, right, that I'm sort of laying out for you when they find themselves in an interpretive quandary. Another is to defer to the agency if that agency's interpretation is reasonable. That is Chevron deference in a nutshell. And then at the other end of the spectrum, another option for that judge might be to defer to the agency no matter what. Let's call this absolute deference. And again, this is something that nobody's asking for, that I don't think anybody thinks is reasonable, but I'm just trying to sort of stake out the full range of possibilities. So that's the key issue that we're talking about today, deference. How to do it, how strong is it, how does it actually get applied?
Okay, so that's helpful. So a couple of questions on that. So one question is, the day before Loper Bright was decided, of those different options, no deference, some deference, just say Skidmore deference, then Chevron deference, then absolute deference, what kind of deference generally, if it's possible to say, were courts paying agencies? Because when I teach a class on this, and when I teach Chevron, right, from the 80s, the idea was that Chevron just basically always applied. But that is not actually the state of the law before Loper Bright.
That's right. And I'd love to get Nick in this conversation too at this point, because that's right. I mean, I think there is some nostalgia for, how much work Chevron has really been doing. I mean, not least because the first step of figuring out if Chevron applies is to look at whether, whether the legislation in question was sufficiently clear that you can tell what it means on its face. As you can imagine, that is a very flexible question, right? And a lot of people can disagree over what it means to be clear. So I do think there are some, descriptive disagreements about how much work the old regime, Chevron deference, was doing when it came to, working through these interpretations in court.
Yeah, I mean, I'll just quickly say, we talk about this kind of sliding scale of possible deference. And where we were prior to Loper Bright was courts were using several different standards to review agency action. So there was a case that came out in the early 2000s, United States v. Meade Corp., that said, actually, we're going to operate in a world where there are two types of deference. We're going to have Skidmore deference, which Bridget called the some deference standard, and we're going to have Chevron deference, which is the more deference standard. And when an agency has the authority to act with the force of law and does so, such as in a rulemaking proceeding, we're going to give them more deference because we think they've considered this issue a lot more, and Congress wants them to decide the interpretive question. But if the agency is doing something that it seems less formal, like guidance, we're going to just say that gets some deference. The agency still has expertise. It still probably understands the law a bit better than the court, but we don't want to give it that kind of more deference standard that we're giving to more formalized agency actions.
Okay, so one more table setting question. So we've established that we have these deferences. By the time we get to Loper Bright, it's actually unclear how often the courts get, or the agencies rather, get Chevron deference, or even how much that means. The last question I want to ask is, Loper Bright, I think, has been viewed very much as a conservative victory, in part because of how the vote came down, 6-3 with the conservative bloc voting in the majority and the three liberals in dissent. And it's also one of these, I think, rare Supreme Court opinions, and especially rare ad law opinions, that has broken into the public conversation, right? It's being covered on Fox News, it's being covered on MSNBC, and everyone generally agrees that this is a victory for conservatives. If you're on Fox News, you're happy about that. If you're at MSNBC, maybe you're not happy about that. Can you, Bridget or Nick, talk about what political valence, if any, Chevron had? Because I think one thing that's important, maybe you can walk us through the history of this a little bit, is that when Chevron was first announced, it was actually viewed as a much more conservative judicial doctrine, and its biggest proponents tended to be folks like Justice Scalia, very much a conservative, and its biggest detractors were sort of good, warned court liberals who believed in the court. So how did that start, and how did we get to this point where 30, 40 some odd years later, Chevron has become this bête noire of the conservative legal movement, and at the same time is, for a lot of liberals, like the only thing standing between us and, I don't know, the end of the administrative state?
Okay, so you're right. When Chevron comes down in 1984, right, it's used to uphold a deregulatory position of the Reagan administration with respect to the Environmental Protection Agency. So for a long time,
and I can't help myself. Not just that, but I think it's just a fun little historical irony. A deregulatory position of the EPA that was then being run by now Supreme Court Justice Neil Gorsuch's mother, which is, of course, it's totally irrelevant to any merits here, but is really fun to just
This
know.
is also, for the record, not the first time we've covered Neil Gorsuch's mom on the Lawfare podcast. She's also a key player in the history of congressional contempt. So just want to put that on the record.
if you're someone who's steeped in this, right, you know that Justice Gorsuch is one of the biggest opponents right now to Chevron deference and the idea that the administrative state can exercise this degree of policymaking authority. So when Chevron comes down, right, it's very much seen as a decision to support the deregulatory efforts of the Reagan administration. And that shifts over time. And it kind of shifts depending on who's president. You seem to like Chevron a lot more if you're in an administration that is producing interpretations and policy that kind of align with your ideological preferences. And at some point around 2016, that shift no longer happens. Donald Trump enters the presidency and begins appointing judges who just kind of have a baseline skepticism towards the administrative state. And as a result, we get quite a few lower court and Supreme Court justices who just are not in favor of Chevron. Now, as a baseline, right, is Chevron liberal or conservative? To some degree, it depends on which policy area you're talking about. If you talk to immigration law practitioners, they hate Chevron deference because it means we should be deferring to the interpretations of the Department of Homeland Security and the Department of Justice, which tend to be anti-immigrant. And so as a result, I think it's more complicated than just saying Chevron is a conservative doctrine or a liberal doctrine. It depends a lot on who's in power and what specific policy area we're talking about.
I think the only thing that I'd add to that is that I do think there's a valence here that runs through not just this case, but a number of the administrative law decisions that we've seen out of the Supreme Court recently, a general skepticism of the administrative state as an enterprise, right? Wanting to trim its sails, wanting to restrain it, wanting to put it back in its lane from their perspective. And so I think that those power dynamics and the sort of rise of that skepticism, has sort of traveled alongside the development of the deference doctrines that we've been talking about today.
So this is really a really helpful discussion, particularly as someone who is not a lawyer. So I want to take us into thinking a little bit more about the specifics of this case. So Nick, can you just give us sort of a run through of what were the facts in Loper Bright? Loper Bright was one of two parties in this case. The other, it's a little bit sad to me that we've identified the case with Loper Bright and not with Relentless Enterprises, which is the name of the other one.
Can we just like change that? Can we just do it out here? Like, because I think we all agree it's the vastly superior caption for this case.
It definitely is. So, Nick, can you just sort of walk us a little bit through the facts of this case and what the majority held?
Yeah. So the Supreme Court ultimately takes Loper Bright v. Raimondo and Relentless versus the Department of Commerce. Relentless should be the case name. And I think if all administrative law scholars refuse to call it Loper Bright, then we just win. Anyway, so they take this case to decide whether it should overturn or clarify the Chevron standard of review. So recall, Chevron's the more deference standard. And in a 6-3 decision, the Supreme Court emphatically holds Chevron is overruled. The facts of the case involve a regulation of the National Marine Fisheries Service, which required herring boat fishermen to have a federal observer on board and pay for that federal observer. But ultimately, the facts aren't really important to this decision, right? We're not here because we're vastly interested in the operations of herring boat fisheries.
Speak for yourself, Nick. As a Russian Jew from Long Island, this hits me where I live.
Well, also, have you guys seen the movie Coda? Right, so this is like one of the threads in the movie Coda is this idea that these fishermen have to pay for the inspectors that they have to host on their vessels, and that this is deeply irksome and super expensive. And so I do think, while I agree that like the larger sort of movement in Chevron here is not about this, the particulars in this case, I do think the sympathetic facts of this do sort of set up the stage for what the majority is doing.
Let me clarify. I have nothing against herring fishermen. I am a mere administrative law scholar, and I am here for an entirely different reason. So, okay. So we have these herring fishermen and they sue mostly because there has been this opening on the court for a long time to challenge Chevron deference. And the court finally, for lack of a better phrase, takes the bait. So writing for the majority, it's a 6-3 decision. Chief Justice Roberts concludes that Chevron violates the law. So let me talk a bit about what law it's violating. Okay, so there's the Administrative Procedure Act, and the Administrative Procedure Act is kind of, you can think of it as the constitution of the administrative state. It's a statute, it's passed by Congress, but it tells courts, Congress, and agencies how we're all going to work together and what procedures the agency has to follow when it makes certain decisions. And Section 706 of that act says, the reviewing court shall decide all relevant questions of law and interpret constitutional and statutory provisions. And Chief Justice Roberts writes, Chevron turns the statutory scheme for judicial review of agency action upside down. Courts are supposed to be the ones interpreting the law. Chevron deference is saying, actually, we should defer to agencies. So Roberts thinks this doesn't comply with the Administrative Procedure Act, and he gets a majority to join him. I want to emphasize, because this gets lost in the discussion sometimes, that the majority grounds its decision in the Administrative Procedure Act, not the Constitution. So it's a statutory holding. Justice Thomas writes a concurrence suggesting that Chevron also violates Article 3, and the majority couches its decision in a bunch of constitutional rhetoric, raising Marbury v. Madison, and it's the court's obligation to say what the law is. But it ultimately decides not to consider whether the Constitution itself prohibits deference. Okay, so Chevron's gone. Since Loper Bright was decided, there's been a lot of conversation among administrative law scholars about where we are. And I think there's 3 ways to read the opinion, and all 3 ways point to a different style of deference that Bridget pointed out. So we can read the opinion so that there's 0 deference, that there's kind of some deference, we'll call it Skidmore, or that there's more deference, that the court actually didn't change Chevron at all, despite all this lofty rhetoric. So, first option, the court has replaced Chevron with what we call de novo review. And that would require courts to arrive at the best interpretation of the statute using traditional tools of statutory interpretation, such as the language dictionaries and a bunch of odd Latin canons that only lawyers understand, without concern for the agency's preferred interpretation. And a cursory glance of the opinion suggests that's what the court did. It uses all this strong language laced with constitutional rhetoric about the court's obligation to exercise independent judgment in deciding whether an agency has acted with this statutory authority. Roberts at one point says, quote, even if some judges might or might not consider the statute ambiguous, there is a best reading all the same. The reading the court would have reached if no agency were involved. And so according to the majority, the APA, the Administrative Procedure Act, means that agencies are not entitled to deference. Agencies can persuade the court that their interpretation is correct, like any other litigant, but they should receive no special treatment. Now, we have only had Loper Bright for a short period of time, but there are some lower courts who are reading the case that way. So there's an order out of the Eastern District of Texas that states the standard of review as follows. In reviewing agency action under the APA, courts must exercise their independent judgment in deciding whether an agency has acted with its statutory authority and should set aside any action inconsistent with the law as they interpret it. A court should no longer defer to an agency's interpretation. There's a separate order out of the Southern District of New York that also refers to Loper Bright as embracing de novo review. So one reading of Loper Bright is we go back to that no deference level, that we're not going to give agencies any special treatment. A softer reading of the court's opinion is that it embraces that some deference standard known as Skidmore. So Skidmore, when it was decided, offered all these contextual factors such as how long has the opinion or how long has the agency's interpretation been in place that courts should use as a sliding scale to decide whether the agency's interpretation should receive greater weight. And throughout the opinion, Chief Justice Roberts emphasizes this kind of long tradition of giving respect to executive branch interpretations of federal statutes. And on a couple occasions, he even favorably cites Skidmore. So another reading of Loper Bright is that the Supreme Court has restored what Kristen Hickman and Matthew Kruger called sliding scale deference. They've gotten rid of that more deferential standard known as Chevron, but they're keeping the Skidmore standard that they said was still alive in United States v. Meade. The final reading, and perhaps my favorite reading of this opinion, is that Loper Bright didn't change anything at all. So the conservative majority, for a long time, this comes up through Justice Gorsuch's concurrences and dissents, is really worried about something called mechanical deference. And that's what the Loper Bright decision calls it. And this refers to the idea that courts simply defer without actually considering the meaning of the statute, or whether Congress has actually delegated authority to the agency. So although there are cases where lower courts appeared to skip a statutory interpretation analysis, most lower courts actually use those tools when applying even the more deferential standard known as Chevron. So despite all this kind of lofty rhetoric about the need for the independent judgment of the courts, there are all these hints that Chief Justice Roberts still believes there's a space for some amount of deference. So he acknowledges that Congress can delegate interpretive authority to agencies, and he outlines several ways Congress may do so. So he says a statute may expressly delegate an agency the authority to give meaning to a particular statutory term. It may empower the agency to prescribe rules to fill the details of a statutory scheme. Or the statute may use terms like reasonable or appropriate to leave the agency with flexibility in how it administers the statute. And if you're familiar with the Chevron opinion, this looks a lot like the rhetoric the Chevron court used to describe when deference is appropriate in the first place. And so, after explaining all the reasons that Congress may choose to delegate to an agency, Chief Justice Roberts then says the court fulfills its role to independently interpret the statute by, quote, fixing the boundaries of the delegated authority. But this is what a lot of administrative law scholars thought Chevron did in the first place. And so it's not wholly clear whether the court has departed from Chevron in the way some people think it has. So we have these kind of three different ways to read Loper Bright, and it's going to be up to the lower courts to decide which reading gets applied in cases going forward.
All right, so let's dig in here. I want to ask a question about Skidmore, and then I want Molly to get to ask all her Congress questions. So Loper Bright, it says Chevron is overruled. So let's just assume for a moment that Chevron is in fact overruled, whatever that means. It also says that Skidmore is still good law. So let's assume that Skidmore is still good law. Now, Bridget, when you were first describing Skidmore, you described it as a some deference rather than no deference standard. I want to ask about that because I think now that Chevron is gone, whatever that means, the exact contours of Skidmore are about to become extremely important. When I teach this in my legislation and regulation class, I introduce Skidmore, but then my punchline is that Skidmore, although it claims to be about deference, is actually no deference at all. Because if you read the list of factors that the court says in Skidmore, it's basically just telling the court, hey, the agency lawyers are really smart and they know a lot of things, and so you should listen to them pretty carefully. But of course, any self-respecting professional judge, right, who's actually trying to come up with the right answer, is always going to listen to smart people in front of them. They're going to listen to smart people if they're from the agency, but they're also going to listen to smart litigants. And so I've always viewed Skidmore as pay people deference when you independently have decided that they know more than you do. But in a way, that's not deference at all. That's just basic rationality, right? In the same way that if I go to the doctor and I ask the doctor to diagnose me, am I deferring to the doctor, or am I just rationally saying, well, I think you know more than I do. I'm ultimately making the final choice, but you're a doctor. You have this fancy diploma on your wall. You've convinced me that you're right. So this is a long-winded way of saying, I personally don't see the difference between de novo deference and Skidmore deference, but tell me why I'm wrong if I am.
I'm not sure you are, because I think once you get into the weeds of these cases, and this is something that Justice Kagan does really nicely in her dissent, is she sort of walks you through a few of the types of questions that end up coming up in these cases. And they are the weeds of the weeds of the weeds, right? It's like, is this type of Western gray squirrel distinct from that type of Western gray squirrel? I mean, this is the weeds. So I guess once you start putting some facts to some of these cases, I think it gets sort of more obvious why a judge would, in the context of any particular case, look at the sophistication of the agency's argument and say, yeah, okay, I mean, I don't know any better than you what makes a squirrel distinct from another squirrel. So we're going to go with what you said, right? And I think that you can call it weight, you can call it judgment, you can call it deference, you can call it a lot of different things. And part of what we're struggling with now is like, what exactly do we call this new world? Is it something different from deference? It's definitely something different from that idea of mechanical deference that Nick raised, this idea that the judge says, well, whatever the agency wants, there you go. I'm not sure a lot of that happens in the wild, to be frank. I mean, I believe that judges are doing what judges are generally supposed to do. And if they were doing that type of mechanical deference, that would violate the old Chevron regime, right? That does not follow the Supreme Court's guidance in Chevron. So I don't know is the answer, and I think that's part of the quandary that we're in right now as a field, is kind of, we need to let the lower courts play this out, see what they do with it, see how they get checked by their reviewing courts. And I don't know, in 5 to 10 years, we'll probably have another name for it, right? But we don't have it right now. And we're all sort of trying on different language to describe what type of thing the judge is doing when it considers the party's argument very carefully, as you say, any judge would.
So I want to go back for a second to something that I think Nick said earlier about the fact that the majority in this case holds that Chevron is a violation of the Administrative Procedures Act, but does not hold that Chevron or other forms of deference are unconstitutional. There is this opinion from, I believe it's Justices Gorsuch and Thomas, that would go that far, but the majority opinion doesn't hold that. So I want to pose the question of, putting aside for a second Congress's multitude of challenges at doing a lot of things, could Congress just reenact Chevron either wholesale or on a per statute basis? Are there constraints to doing this? What are your thoughts on that question?
So I actually prepped this question because I knew Molly was on the call, and I thought there was a good chance it would get asked. So the court decides Loper Bright as a matter of statutory interpretation, but leaves open the constitutional question, which makes it initially seem like Congress could restore Chevron deference by statute. So members of Congress have proposed bills to protect Chevron deference even prior to the decision in Loper Bright. So the Stop Corporate Capture Act was introduced, and it would have amended the Administrative Procedure Act to require courts to, quote, defer to the agency's reasonable or permissible interpretation of a statute, regardless of the significance of the related agency action or a possible future agency action. And ostensibly, right, if we believe the court is just holding this as a matter of statutory interpretation, the act would restore Chevron deference and eliminate what is also called the major questions doctrine, which prohibits agencies from answering questions that are politically or economically significant. That said, Justice Thomas writes this dissent that says, actually, Chevron's a violation of Article 3, that only courts can interpret the law. And the majority includes all this rhetoric about the Constitution and the role of the courts. And so it's not clear to me that if something like the Stop Corporate Capture Act were passed, that Chevron would survive. I think this was the narrowest holding Chief Justice Roberts could pick, and he didn't want to reach the constitutional issue. But push comes to shove, I'm not convinced restoring Chevron deference would survive the current Supreme Court's understanding of Article 3.
That's really interesting and sort of gets at the next thing that I also want to ask about, which is that you can read some folks, including folks who I think are quite smart about the US Congress, argue that we should think of this as sort of a moment of opportunity for the Congress. That the response to this from a separation of powers perspective should be for Congress to, really beef up its internal capacity and expertise and be prepared to write more detailed statutes. I will admit that I am somewhat skeptical of this line of argument, but I'm curious, as someone who, thinks about the Congress as a sort of political body and a political institution, and as I think Bridget alluded to at the top, as a institution that is constantly making compromises on its way to its ultimate legislative products. And so that sometimes the sort of ambiguity and delegations of authority we see are on purpose and not by accident, and that doesn't change. But I'm curious for sort of your reactions as kind of folks who come at this from a legal perspective. Should we buy this argument that this is a moment for Congress to try and rise to the occasion, or do you share some of my skepticism of that line of argumentation?
I mean, I think for a lot of reasons, a lot of us would love it if Congress said, "Sweet, let's get back to the drawing board, guys. Let's revisit these old compromises. Let's pick up these statutes from many decades ago dealing with modern problems so that agencies are struggling to apply to modern problems." I mean, yeah, cool, great. That'd be awesome. But there's not really been anything holding them back from it. So we'll have to see. I mean, when I talk about kind of waiting for the chips to fall, what I mean is both, what are the lower courts going to be up to? And also what kind of incentives does or doesn't this shift, for Congress? So I don't know. I mean, hope springs eternal. That would be great. Although I do think that the pursuit of precision is something of a fool's errand because of the compromise process that you described, Molly, but also because, legislators are humans too. They can't see around every corner. They can't envision every possibility. And even if they had, all the time in the world, really couldn't imagine all the things that life's going to serve up for us and new technology is going to provoke and changes on the ground are going to provoke, social trends are going to provoke. So, this idea that the majority opinion uses, this idea that, statutes have a knowable sort of fixed meaning at the time of enactment, and that's what judges should be looking for, I think just really it doesn't match my understanding of how legislation actually gets drafted. And this is also one of the points that, Kagan brings up in her dissent, that we've known for a long time, thanks to great work by Vic Norris and Abby Gluck and others, that, the way Congress works is not necessarily this way. So there's sort of a belief that that when Congress acted, it was a complete accounting for everything they wanted to accomplish right there on the page. And so there's really no need to sort of fill in the blanks because it's all right there for the taking. And I don't know a person who studies Congress that think that that's actually how legislation gets written.
I don't either. So.
Right. Which seems like a pretty significant problem for the majority's view, right? This idea that, it's not just that Congress could be more precise in the future, right? It's not just about stimulating future legislative output. It's about saying the things that they've written were already quite clear and knowable, based on what they've done. And I don't agree.
So I want to make sure that we have some time to talk about some of the other important ad law cases. But before I do that, I want to ask you one last question about the new world of Loper Bright deference, whatever it is. And that is, we've been talking in this conversation generally about administrative agencies, but this is Lawfare. We do hard national security choices. So I want to take a moment to think about, what, if anything, we can say about those substantive areas that sort of are of particular interest to Lawfare, whether it's national security or foreign policy or tech policy. Is there any reason to think that Loper Bright again, whatever it ultimately ends up meaning, will play out differently in these domains than in the rules regarding herring fishing, for example?
So I think it will play out differently in both foreign affairs and tech policy for two sort of separate reasons. To start with foreign affairs and foreign policy, the Supreme Court has often applied a different deference doctrine in these sort of cases, and it's called Curtis-Wright deference. And Curtis-Wright deference is this idea that courts should afford greater deference to executive branch actions in the foreign affairs context because the president has plenary power in the foreign affairs arena. Given that's a constitutional hook, it's not clear to me that Curtis-Wright deference is going away. And that's closer to being kind of the super deference Bridget referred to. So there's this study by Bill Eskridge and Lauren Baer that looked at the Supreme Court's deference doctrines, all of them, for some period of time. And it found that when the court invoked Curtis-Wright deference, it always deferred to the executive branch. Now, there's some subsequent literature that suggests maybe that's waning a bit. But given that this court hasn't been shy about expanding or preserving presidential power, I don't really see that going away. With respect to tech policy, I'll just point back to something Bridget said earlier, which is, yes, there are certain cases that are really politically salient that involve tech policy, such as the net neutrality decision. But a lot of stuff concerning technology and, regulated industries is really complicated technical scientific determinations that the courts do not want to wade into. If you talk to like a DC Circuit law clerk, they will tell you the scariest opinion they can encounter is something where they have to write about the Federal Energy Regulatory Commission. They don't want to get involved in those kind of highly technical cases. And so I think we're going to see different win rates under Loper Bright, or what we should be calling relentless deference, based on kind of how specialized and technical the agency actually is.
Yeah, and a version of that describes, how deference worked before Chevron deference, right? Chevron did not create this concept of deference. Judges have long been faced with that interpretive question and those sort of four options that I laid out at the top, right? The issue comes in, they've got two parties in front of them. One says the statute means X and one says the statute means Y. Judges have had to figure that out for as long as we've had statutes and judges, which is to say, for a very long time. So that's going to continue to be the case. And so, and if you look back at how courts handled these questions, pre-Chevron, they sort of waded through it, right? And a lot of times they did give weight or deference or whatever you want to call it to the agency in mind. So I think, for example, for an agency like FDA or FCC, where you've got, a high degree of technical knowledge, scientific knowledge required in order to make particular determinations, I'd be surprised if you don't see judges, at least some judges, continuing to say, yeah, okay, you got this, right? We're going to go with what you recommend. And that is itself part of the judging role. So when the majority opinion in Loper Bright says, we need to put judges back in the driver's seat for doing this interpretation, part of the process of doing an interpretation is taking in, the different arguments and giving them the appropriate weight. So there's a version of this that is just where that process of deferring to an agency just gets sort of nested within the interpretive exercise itself. And judges are free under Loper Bright to, give agencies that kind of weight when they see fit.
So Loper Bright, not the only significant administrative law case that the court decided this term. There's another case that I'd like to make sure we touch on at least briefly, because I think it is also consequential, and that's a case called Quarter Post versus Federal Reserve. Bridget, can you tell us a little bit about sort of what's at play in that case and kind of why it's important? Obviously, we spent most of our time talking about this idea of deference, but I think there's some big questions that come up in this case as well.
Yeah, absolutely. Thanks. And I agree. I mean, there actually were several administrative law decisions that came down this summer, and I mean, to me, corner post is as significant, if potentially not more significant, than Loper Bright. So, in the interest of time, I'll just give you the punchline of that case. The Administrative Procedure Act has a sort of 6-year statute of limitations on agency action, right? So you've got sort of a 6-year clock, and the question has been, when does that clock start? Right? What starts the trigger to run that clock? So we've been working under the idea that the clock starts when the agency action is final. So in the rulemaking space, it's basically when the agency issues a final rule. So the proposed rule isn't enough. The agency has to have gone through the comment period, issued the final rule, for example. In corner post, the big change is that the majority decided that the statutory trigger's use of the word accrues means that the starting clock on the 6 years is more about the particulars of the plaintiff rather than, the position of the particular agency action. So in corner post, you've got a new entrant that wasn't around when the rule was promulgated, pops up later, and then is injured by that rule. Corner post stands for the idea that that plaintiff still has the ability to challenge a rule, perhaps decades after it was promulgated, because that harm has accrued to that plaintiff, within the 6-year period of that plaintiff basically, becoming aware of it. So that's the big shift. And that's a very big, that type of decision really supercharges, the consequences of something like Loper Bright or any of the other administrative law cases that have been released by this court, as well as, prior courts, things like the major questions doctrine, for example. It basically widens the scope of how many rules are up for grabs through, by being challenged in court, because that 6-year clock has just vastly expanded.
So one interesting thing about Loper Bright is that, and I'll get to corner post in a second, but I think it's an interesting comparison. Loper Bright, the Chief Justice specifically says, to be clear, any rules or regulations that have been upheld under Chevron, they stay upheld. So there's no retroactive force of Loper Bright. I haven't read corner post as carefully as I'd like to. Does the court say anything about that? Or is now literally every rule rather that has ever been enacted, if there is a new entrant or someone can claim, hey, I've just been injured, now they have 6 years? Because that would be a huge difference in the potential impact of these two cases.
Yeah, I mean, it's the latter, right? So it's really
Yikes.
Yeah,
which is the technical ad law term.
We do that one a lot, actually, in administrative law. We do yikes a lot. Yeah, no, that's right. And that's why, to me, when you think about the significance of these cases, I understand that Loper Bright is the sort of headline maker, because Chevron deference is a big deal in administrative law. But you're only at the point of dealing with deference once you've gotten through all of those other threshold issues that you need to jump over in order to get into court. What corner post does is make it that much easier to get into court, and therefore expands the pool of potential claims, right? Expands the number of cases that these courts are going to have to hear. Exactly how widely that ends up opening the aperture, basically, is part of what, I'm curious to watch as lower courts try to grapple with, what corner post actually means for the administrative state. But if it means what it looks like it means, it does mean that a new entrant that, experiences harm is going to be able to upset and challenge, rules that are potentially very, very long settled. So that is, to me, that is a more seismic type of change than the one that has gotten so much attention because of Loper Bright.
Before we close out, I want to zoom out and talk about this term and this court more broadly as it relates to administrative law, but also to executive power generally. So obviously there's a lot of uncertainty about what Loper Bright deference means, but I think between Loper Bright, between corner post, between other administrative law cases, I think it's fair to say that this court, the Roberts Court, the conservative wing of it, is more skeptical of administrative agencies than, even conservative justices have been in the past, not to mention liberal justices. And yet at the same time, we're seeing cases I think obviously the highest profile case this year, even higher profile than Loper Bright, of course, I'm referring to the immunity case, Trump versus United States, in which the court simultaneously seems to want to give at least the president a lot more power. And there are other administrative law cases from previous terms about, in particular, removal authority, again, giving the president more power. So you have these two things which I think, at least on their face, appear to be at least somewhat in tension. Because, of course, the administrative agencies, they're not a fourth branch of government. They are in the Article 2 branch. Ultimately, and maybe the independent agencies here are a little bit differently, but a lot of the kind of core agencies are accountable to the president. So you have simultaneously a court that is trying to weaken the administrative state, but simultaneously empower the president, who is in some sense the boss of the administrative state anyway. So is this inconsistent, or is there some through line here that may not be immediately obvious? Let me start with you, Nick, and then we'll go to Bridget, and you should also free to riff more generally on where the court seems to be going when it comes to sort of all things Article 2.
So the court has clearly taken a strong unitary executive theory position over the last about 5 years. It's very clear that it reads Article 2 as endowing the president with a significant degree of authority over federal agencies. What I think the court and sometimes scholars of that theory fail to recognize more generally is that the president needs the administrative state to do a lot of what execution of the law looks like in the modern day. So Andy Rudalevich has a book on executive orders. We think of executive orders as like the top statement from the president, right? It is the most presidential of actions. And what Rudalevich finds is that actually a lot of executive orders are created from the bottom up, that an agency has an idea of something it wants the president to issue, and it drafts an order pursuant to that. My own work empirically looks at rulemaking and how presidents rely on federal agencies for capacity. So I think that tension's absolutely right, that the court wants to increase presidential power in some way, but it doesn't necessarily appreciate that it might be harming the president's ability to take care that the laws be faithfully executed by diminishing the power of federal agencies. And I don't know how to resolve that tension, but it's certainly present in these cases. And I think it's just going to become more apparent as the court continues to tinker with the structure of the administrative state.
Yeah. I agree that there seems to be this delineation between the president as an institute, the presidency, I suppose, as an institution, and the administrative state. I think the thing that helps me reconcile the tension that you describe, Alan, is that I think simultaneously the skepticism about the administrative state is partly a frustration with Congress's passivity, right, and unwillingness to touch those old statutes and bring them up to speed and settle new disputes. Nick mentioned net neutrality earlier. I mean, if Congress, it's such a big policy. We have these huge policy questions, right? Thinking about climate change, thinking about net neutrality, thinking about all kinds of things, where if Congress could come to the table and legislate, we would then have more clear direction for an agency to follow, to execute, right? And so I think that in something like Loper Bright, the court is sort of taking aim at the administrative state, how much power it has, but in a way that is a pretty strong nudge to Congress to get into the game. So whether that's the court's role to sort of police, legislative activity, we can have disagreements about that. But I do think that's part of what's going on there, is a frustration with, agencies using old statutes to address new problems and filling the vacuum, basically, that Congress is leaving when it fails to legislate. Also, agencies stepping into that vacuum and filling that space simultaneously reduces the pressure on Congress to legislate in some ways. So that might be part of what's going on here, and sort of how you can simultaneously want to empower the president while clipping the wings of the administrative state.
The other thing that I'll say on this question, I'll steal the moderator's privilege and say, is that another sort of thing that links these two sets of arguments is that while it may present two different views of the power of different parts of the executive branch, they share a very vigorous role for the courts themselves. And so one, I think, again, for me, as someone who thinks about these questions in kind of a broader separation of powers perspectives, another answer here is that we are seeing the court sort of continue its project of enhancing its own power, the power of the federal courts generally, even if that means taking kind of two different tacks on the power of specific parts of the executive branch.
Molly, we almost made it through a podcast about Loper Bright without saying towards judicial aggrandizement, and that was a mistake. So thank you for pulling us out of that.
My pleasure. I very much enjoyed this conversation. I think we will leave it there for today. Thank you, Alan. Thank you, Bridget. Thank you, Nick, for this conversation.
The Lawfare podcast is produced in cooperation with the Brookings Institution. You can get ad-free versions of this and other Lawfare podcasts by becoming a Lawfare material supporter through our website, lawfaremedia.org/support. You'll also get access to special events and other content available only to our supporters. Please rate and review us wherever you get your podcasts. Look out for our other podcasts, including Rational Security, Chatter, Allies, and The Aftermath, our latest Lawfare Presents podcast on the government's response to January 6th. Check out our written work at lawfaremedia.org. The podcast is edited by Jen Patja, and your audio engineer this episode was Noam Osmond of Go Rodeo. Our theme song is from Alibi Music. As always, thank you for listening.